In today's video, we help you further understand some of the important FDA rules around labeling your product. Hi, I'm Michael H. Cohen. I'm founding attorney of the Cohen Healthcare Law Group. We help healthcare industry clients just like you navigate healthcare and FDA legal and regulatory issues every day so you can continue to scale or launch your health and wellness product. In a recent video, we talked about how FDA looks not just at the label that you peel on the product, but everything you say in your marketing about your product. FDA calls all of this your labeling, not just one label. What FDA is looking for is whether you are sticking to structure function claims, which you're allowed to make for supplements, if you're dealing with a dietary supplement, or whether you're making disease claims, we also call them drug claims, which are unlawful and will cause your dietary supplement or cosmetic product to be regulated as a drug. As the manufacturer or distributor of a dietary supplement, you can't afford to have your product regulated as a drug because you don't want to spend years and years and years and millions of dollars on clinical trials establishing safety and efficacy. You simply want to say supports this or boosts that, and in the overall context have that be a safe claim, get the product on the shelves, get it sold. But sometimes it helps your marketing, it boosts your marketing, it supports your marketing to be a little bit more aggressive in your claims. Now, that in itself is not a bad thing, but that's where it can be worth a lot of money to have a lawyer who is proactive, who understands the nuances, knows where you can push the marketing probably, and when you can be assertive, but when your claims are so aggressive that they're likely going to tip the balance into the drug claim territory. And I say probably because there's always a judgment call and you always make a business judgment. Now, large companies, you can't make a move without going to the lawyers. You can't put a claim on the website without the legal department coming down. A lot of times they'll come down heavy because if you get it wrong, the company gets slammed by FDA, and you'll also have headline news. So you don't want to be on, you don't want to be in the news. But smaller companies sometimes don't realize this, and they typically, tiptoe around trying to get the cheapest quote for label review. Sure, you can train a paralegal to review a label for technical compliance, but that's not the same as having good sense and experience and judgment as to the nuances of product labeling, including the claim, and understanding FDA's tolerance or not for little marketing flair. The difference between a claim that draws FDA fire and one does not can be very subtle, and so can effective marketing and a good campaign versus one that's dull, dry, plain vanilla, boring, just because a lawyer always says no. So please note, the phrase plain vanilla has not been approved by FDA. I'm just kidding. I'm giving you a metaphor. FDA doesn't have to approve everything, certainly not plain vanilla. Even plain vanilla. But, they can do something very simple. They can go into the search bar of Google and they can look for terms. And in this way, FDA can very easily catch you if your marketing terms make claims that FDA considers unlawful for dietary supplements or cosmetics. One last tip, don't rely on other companies to do the work for you, even if they're big manufacturers or redistributors, and I assure you that all is well in Denmark. Don't rely on them vetting the claims. Get your own legal counsel. I used to say, don't roll the dice, get legal advice. Thanks for watching. If you still have questions, please click on the link below, CohenHealthcareLaw.com, to send us a message or book an appointment. We'd love to hear from you. We look forward to speaking with you soon.